Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review. Thank you for listening. Here's Beth Mulcahy.
Good morning, everybody. How are you? Happy New Year. I'm just going to let people join as we start our Tuesday, January 16th Neighborhood Services Virtual HOA Academy. So hi, everybody. Happy New Year. I can't believe that it has been nearly 4 years since our first virtual class, and I look forward to many more in the future. This virtual platform continues to be a success for educating board members, managers, and other people who are interested in the community association industry. And it allows us to reach more people than ever. So thank you so much for participating and providing positive feedback to us on the fact that you're liking our classes. Welcome to our first class of our 2024 Virtual HOA Condo Academy in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. My name is Beth Mulcahy, and I'm the founder and senior partner for the Mulcahy Law Firm in Phoenix, Arizona. First of all, Happy New Year. I wish you and your association a healthy and prosperous new year. I've represented over 1,000 HOAs and condominiums in the state of Arizona as their legal counsel for the past 27 years. I also currently serve on my HOA board and have for many years. So I think I bring kind of a unique perspective to teaching these classes because not only have I been an attorney that's helped boards and associations navigate their legal problems for over a quarter of a century, I also have been on my board for a decade. And I also had a small stint as a disgruntled owner in my community when I was not on the board. So I think I really do understand a lot of different perspectives as I teach these classes and try to provide the most helpful information so that you are running successful associations. What's on today's agenda? First class for 2024. Today it's going to be 2024 Unwrapped. We're going to be exploring hot topics and headlines for the new year. We're going to cover a variety of topics today. It's going to include the new legislation for 2024 in Arizona, the Corporate Transparency Act, deferred maintenance and master planning in an association, how to disaster plan for your association, electric cars, social media pitfalls, recruiting board members if you can't find a board member for your community or you can't find people to run for the board, and then artificial intelligence such as Chat GPT and how that may affect our industry in the future. As always, there's going to be a free Q&A at the end of the class, so I encourage you to submit your questions via the chat box on Zoom or in the comments section on Facebook Live. Please be sure to limit yourself to one question per person and be as specific as possible, as there will be an opportunity for a follow-up if I don't understand your question when I read it. Okay, before we get into today's class, I always like to know who's with us. So I like to have a poll. So for those of you who are with us on Zoom, the poll is going to be right there on your screen. For those of you who are with us on Facebook Live, if you could just put your answer in the comment section. So the first poll question is, in which city do you reside? So this would be where your association in Arizona is located. And so we have all the 10 different options. The second question is, please let us know your current role in your association. Are you a board member? Are you a community manager? Are you an interested homeowner? Or are you something other that might be just here to listen and fact find? Okay, while we're waiting for those poll results to come in, we're going to be talking a little bit about the new year, 2024. And a great thing to do at the beginning of each year is to think about what are your goals for your association. And I mentioned when I taught the first Friday class a couple of weeks ago that I was working on goals for my law firm, for my personal goals, and then also for the association board that I'm actually on 2 boards right now, a master board and a sub board. And so really thinking as a board member here, if you're a board member who's listening in on this class today, I want to share with you a worksheet that could help your board set some goals for 2024. I really suggest that all associations at the beginning of 2024 come up with at least 5 goals that you want to accomplish in 2024. Our firm has helped many associations develop, plan, and achieve goals over the past 27 years, and this is a very effective tool to get you started. So we're going to be I'm sharing with you the worksheet on goal setting, and I hope that your board will pop that out in your January or February board meeting and, start writing down some goals. What typically happens in associations is we get so busy being busy, dealing with maybe a homeowner that's upset about something, or dealing with violations, or just dealing with the day-to-day minutia of running an association, that we forget that we need to also be thinking big picture. We need to be doing some strategic planning for your association and maybe tackling some deferred maintenance. We're going to be talking about deferred maintenance later today, or maybe you have a very large project that needs to be accomplished in your association, like painting or re-roofing or redoing your pool. And setting up a goal worksheet for that and adding that to your goal worksheet is step one. And then we're going to be talking a little bit later today about master planning and how to accomplish those goals. So stay tuned, because we're going to help you get there this year in 2024. Okay, I'm going to be returning to our poll results now. Looks like we have our results back, and we have a great representation from almost every city in the Valley today. We have approximately 2% from Avondale, 8% from Chandler, 5% from Goodyear, 23% from Mesa, 8% from Peoria, 25% from Phoenix, 20% from Scottsdale, and 3% from Tempe. Now, to our friends in Surprise, I am so sorry. I forgot you today. So I apologize for that. I inadvertently left you off our poll. So if anybody's here from Surprise, I promise I'll make it up to you. We'll be sure to have you on our poll next month. Okay, the second question was, let us know your current role in the association. So we have 60% here today are board members, 9% are managers, 25% are interested homeowners, and the other are 5%. So we have really kind of a good representation. We don't normally have as many interested homeowners. So glad to see 25% here today listening to the classes. Okay, let's go back to our, main topics for today. So one of the first topics we're going to talk about is legislation in Arizona. So a couple of things that you need to be aware of. The 2024 legislature opened last week, and we already have over 700 bills that have been introduced, and we're already looking at the 10 bills that have been introduced that directly impact HOAs and condominiums. And we are monitoring the bills every month, or every week, during the time that the legislature is in session. And just like we've done in the past, we're going to talk about these bills in our classes throughout 2024. And we also will be posting on our website, mulcahylawfirm.com, a summary of the new bills. Since it's the beginning of the legislature and we're just kind of coordinating, putting all the bills together on a spreadsheet, probably by the end of this week, if I had to guess, by Friday or Monday, we'll have our first summary ready for you. But really, I did a quick look at the bills on Friday of last week that had been introduced so far. And there was a couple surprises, but mostly it's just fine-tuning and more regulation of associations that we're going to be required to comply with. So we'll keep you posted. The first time we're going to be talking about it officially is going to be at our next first Friday, the first Friday in February. So I hope you'll join us so we can have a live discussion on what's going on. Remember, one other thing on the legislation is that this time of the year, we kind of get an avalanche of bills, and we don't want to overreact. What we do is we start monitoring the bills. And remember, this is a marathon. This isn't a sprint. So what happens is over the next 6, 7, 8, 9 months, like it was last year, in 2023, the legislature fine-tunes these bills, and they combine some of the bills. Some of the bills never move out of committee, so they're dead. And so what we want to do is we want to just kind of give you a quick introduction to them, right now. And in February and March, and then in April, we start talking about the bills that really are moving and that are likely to become the law. So that's kind of our game plan this year in 2024 for new legislation. You have my word that we're going to be watching it every single week and posting on our website an update as to what's happening that pertains to HOAs and condos in the Arizona legislature. So check out our webpage. We will try to have that posted every Monday throughout the time that our legislature is open. And then again, our website is mulcahylawfirm.com, and we usually put a link right in the middle of the homepage of our webpage starting next Monday. Okay, we also had some legislation that was introduced in 2023 that impacted associations. I know that we talked about that extensively throughout 2023. There were 5 bills that were passed in 2023, and they went from adding a flag, the Betsy Ross flag, to the flags that owners can fly, to some special requirements for condominium insurance, to a bill on public roadways, and some important information about associations that are planned communities and that the streets are dedicated to the public, some actions that your association may or may not need to take in the coming years. Also, there were political activity bills, just like previous years, talking about, can somebody come into a gated community and distribute political materials or ask for signatures regarding political petitions that pertain to, non-HOA issues. There's a bill on that. And then there also is an important bill on board member removal that says that if the association doesn't act, if a condominium or planned community association doesn't act on a petition that's submitted for removal of a board member or multiple board members, and have the meeting to vote to remove the director within 30 days of receiving the petition, the entire board is removed. So that obviously was a very interesting and a bill that has serious consequences for associations. So we have a legislative summary that I'm going to be sharing with you. Please take a deeper look at that. If you have any questions, you're always welcome to reach out to our firm or me individually at bmulcahy@mulcahylawfirm.com. Okay, let's switch gears and talk a little bit about a federal law that we need to keep on our radar in 2024. So if you haven't heard about it, this is something that you definitely need to be thinking about in 2024, because this bill that was enacted by the United States Congress is called the Corporate Transparency Act. We're going to be sharing with you a summary that the Community Associations Institute prepared. It's kind of a deep dive on what the Corporate Transparency Act is and who it applies to. And so just a quick overview of the Corporate Transparency Act. It is a federal law that was passed in 2021. And the purpose of it was to track criminal or terrorist money laundering. And the goal of the Corporate Transparency Act was to safeguard national security and the United States financial system. So a question that we're getting is, does the CTA apply to HOAs and condos in Arizona? So the short answer is yes. Now, if you are set up a certain way, as some corporations like 501c, I think it's C5s, I've got to check my records on it, but there are some exceptions. You'll see it on CAI's summary. They give a detailed summary. So if you're an association that doesn't pay taxes or doesn't file tax returns, it's possible that this may not apply to you. But 99% of our associations that are condos and planned communities in Arizona, this will apply to you, unfortunately. So short answer is yes, it's going to apply to you. However, I just want to state this little caveat that there are many industry professionals, myself included, throughout the U.S. who do not believe that the Corporate Transparency Act was intended to apply to HOAs and condominiums in Arizona or anywhere in the U.S. I've never heard of an association being involved in HOA or condo being involved in criminal or terrorist money laundering. And so I think the broad language of the Corporate Transparency Act may have swept in, some charitable organizations and nonprofit organizations that really they didn't intend to sweep in and require compliance with this law. So for now, the 10K or so HOAs and condos in Arizona must comply with the reporting requirements, and I'm going to talk about those in a second, that are in place under the Corporate Transparency Act. The good news is, although the law went into effect January 1st, 2024, you are not required to provide the reporting information under the Corporate Transparency Act until January 1st, 2025. So what we're doing and what we're advising our clients to do is keep the Corporate Transparency Act on your radar in 2024. And you can be sure as can be that we are going to be talking about it as a firm on these classes and with our clients about whether there are any changes. Maybe the United States Congress passes a bill that carves out some of these charitable nonprofit organizations, including condominiums and planned communities. Maybe that happens in 2024. And we aren't subject to it by 2025, January 1st, 2025. But I'm doubtful that that's going to happen. I think we are going to have to comply with it. But if something changes, I guarantee you we'll be talking about it here. So what are the requirements that we have to report under the Corporate Transparency Act if we're one of the HOAs or condos that this applies to? Which again, it's going to be pretty much widespread compliance for HOAs and condos in Arizona. So by January 1st, 2025, we're going to have to fill out a form that the government has created, and there's a link to it that is now available online. And as we get closer to the compliance date of January 1st, 2025, we'll be sharing the link with you and helping you fill out the form. And so basically, what's the information that's on the form that has, helps us comply with the Corporate Transparency Act? So we have to provide the business name of the association, which is obviously easy, but this is kind of the harder part of it. We're going to have to provide the following information for board members and any individuals who have substantial control over the association. Maybe that's going to be the CEO of the management company, if you have one, or maybe the CFO, the corporate financial officer of the management company, if there is one. So all board members and any person who has substantial control over the association has to provide this information. So they have to provide their legal names, their birth dates, their home addresses, and their driver's license, state IDs, or passport numbers. And so it's kind of, a little bit intrusive, right? So we're serving on this volunteer board, and I'm going to have to comply with this. This is something I'm on two boards, so I'm giving this information to, the government on two different forms. So again, it's a little bit uncomfortable, right? But I was on a call last week with colleagues from around the country who do what we do, represent associations. And somebody on the call made a really good point. They said, listen, at least two other government organizations or entities have this information already. I don't really understand what the big whoop is that we have to provide it. I think probably when that person said that, I kind of did have to agree. What I think the thing that bothers me about this law is that, no association is engaging in terrorist activities, right? And it's an example of overreach by the federal government that's going to cost us money. And ultimately, who pays this? It's going to be passed through first to the board, and then the board's going to have to budget for this. And then it's going to get passed through to the homeowners, and homeowners are ultimately going to have to pay more in assessments. This is just a form. It probably shouldn't be that big of a deal, but there's going to be a charge, whether the management company charges for it or maybe your law firm charges to help you with it. And that's an extra charge that you didn't have, in 2024. Remember also that this is an ongoing reporting requirement. So any changes, corrections, or additions to the filing must occur within 30 days of any change. So if you have a board election and you have a new board, you're going to have to update the form with the new information of the board members. If you have a board member resign or you appoint a new board member to the board, you're going to have to update the information within 30 days. If you change your management company, or if maybe a key person at the management company who's considered somebody who has substantial control over the association changes, they change jobs or whatever, and you get a new person in, you're going to have to update that information. So it's an ongoing reporting requirement. And it's just something we want you to be aware of, that it's starting January 1st, 2025. So definitely this is something we got to keep an eye on in this year. Okay, a couple things. If you don't comply with this, not trying to scare you, but they do have civil penalties of $500 per day, and then criminal penalties of up to $10,000 and a maximum of 24 months in prison if you do not comply. Now, obviously, I think those are probably for the organizations that are truly terrorist organizations or money laundering, but it's part of the law. It's what it says. So it's something that we have to take very seriously. And there's going to have to be something put in place to make sure that associations are fully complying with this by January 1st, 2025. Okay, our next topic is deferred maintenance. Honestly, I don't think that there is any association in Arizona that doesn't have some issues with deferred maintenance. So what are examples of deferred maintenance? Maybe you have a clubhouse and the things are getting a little bit run down in the clubhouse. Maybe the paint is peeling or the roof is leaking, and people aren't using the clubhouse very often at your association. So it's just something that exists, but you just keep putting it off because it's going to be a big project and it's going to cost $100,000 to fix. And you just keep putting it off every year. Or maybe You have your irrigation system at your association is malfunctioning frequently, and you have to go in and override it. And you're just kind of band-aiding it every month. And at some point, there's going to be a day that it's just going to break and you can't fix it, right? And there are so many examples of deferred maintenance in associations. And the problem with deferred maintenance is that over time, it really does start to affect property values. And over time, it does kind of create board member burnout because there are so many problems and there's not enough money frequently and not, maybe even a desire or ability to get it done because maybe you can't get the special assessment pass to pay for the upgrades that are needed or the maintenance that's needed in the common areas. So it's frustrating. It's a frustrating issue and a lot of associations are dealing with it. So what are some things to think about? A good place to start if you have deferred maintenance is address it, right? Don't keep, sweeping it under the rug. So the first thing you could do to address it would be create a maintenance backlog. So have a walkthrough of your property and start writing down what are the issues that, may need to be addressed that are deferred maintenance. So just creating a list starts the process of, okay, here are some things that probably need to be addressed. If you have a management company, maybe your management company property manager can help you create that list, or maybe you bring in a third-party expert to help you with this process. Then the next thing you want to think about is what's the scope of the problem? After you see the list, is this something where we have a lot of issues and we need to maybe bring in a master plan to help us get this done over a 5 or 10 year period? I know my association where I live is 50 years old. And right now we have a lot of deferred maintenance, and it's kind of a difficult situation because we don't have the majority votes on our board to aggressively attack this deferred maintenance. So it's kind of like we're in a waiting period where until we get the votes, we really can't do anything. And so, it just depends. After you look at that maintenance backlog, that list of things that need to be done, you should reach out to your trusted advisors, whether it's your reserve company or your attorney or your management company, and talk about it and say like, okay, how serious is this issue? Is it something that we just have a couple of things that we can start planning in 2024 or the next few years and get it done? Or is this something where we need like a major overhaul and we're looking at like maybe 5 to 10 to 15 million to get this place back on track? If you're in the range of $5 million projects to get the deferred maintenance fixed, you really do need to bring in an expert. There are companies throughout the United States that help associations with what we call a master plan. And they just identify what are the things that need to be accomplished. And then they help you come up with a plan on, over the years, what would be a good plan to get it done. And they help you with the marketing on it to your owners. And it's really a good thing to do if you're an association that's in that situation. It does cost a little money to hire these companies, but it's money well spent in my experience. So after you create your maintenance backlog, then look at, is this like a small type of maintenance things that we can just start planning out over the next year or 2 years? Or is this something that these are more serious issues? Like maybe it's $1 million, $5 million, $10 million and up. You may want to bring in a master plan company to help you. And if you need names for some referrals for those, you're welcome to reach out to me. I'm happy to give you names of any companies that we have worked with in the past with our clients and that we've had a good experience with. Just email me directly at bmulcahy@mulcahylawfirm.com and I can share those with you. Okay, then we got to talk about how are we going to pay for this, right? If we have a lot of deferred maintenance, A, you got to get the votes on the board to, move forward with it. And then B, how can we fund this? So maybe it's something that you're putting in your budget for the next year or this year. Maybe you have to do a special assessment. And if you're doing a special assessment, make sure you're reaching out to your trusted advisors of your management company and your attorney to make sure that you're doing it correctly and getting the proper votes that you need from the homeowners. And if you may have to have a homeowner meeting to have them vote on it in person or by absentee ballot. Okay, first the board's got to approve moving forward on the deferred maintenance. Then we've got to fund it. So how are we going to pay for it? And then kind of the next step is moving forward. One thing I want to mention on this is typically it's hard to tackle deferred maintenance. Usually there's some people that don't see deferred maintenance and they're saying, well, everything looks great here. Why do we need to fix the peeling paint? Nobody's even noticing that. Well, so if you are moving forward with your capital improvement projects to fix some of these deferred maintenance issues, you want to make sure you're picking the right vendors, because if you pick a wrong vendor, it can be a very costly mistake. And so we're going to be sharing a bunch of cheat sheets on, some of the topics that I've been talking about here under this deferred maintenance topic. And one of them is association bidding and contracting. So when you're selecting your vendors, take a look at that cheat sheet. If you're, doing a big project like painting or something that's going to cost over $100,000, you should definitely be looking at that cheat sheet to give you some recommendations. But just some quick recommendations is make sure that you're hiring a vendor that's licensed, bonded, and insured. Make sure that obviously check with the Register of Contractors in Arizona, see if they have any complaints. That's always a bad sign when you see a contractor with one or more complaints that haven't been resolved. And even if they have been resolved, it's a question you need to ask of them. Why do you have so many complaints with the Register of Contractors? Picking the right vendor is important because these projects are expensive. And if you pick the wrong vendor, like let's say you go with the lowest bidder and they're not licensed, they're not bonded. If they screw it up, you're going to end up paying twice as much. So you would have been better off going with the licensed, bonded, reputable, check their references vendor who is going to come in and knock it out of the park and do a good job. A couple things on deferred maintenance I just want to mention kind of in closing would be reserve funds and doing reserve studies. So we have a great cheat sheet on this that we're going to be sharing with you on reserve funds as part of this deferred maintenance topic. But really what we're hearing from reserve companies, specialists in Arizona that are licensed to do reserve studies is that you really need to be doing them now every 3 years. Some of you may have noticed that the cost of some of these projects is going up exponentially. And that's due to inflation and other factors. But, you may have a reserve study from 5 years ago or 10 years ago, but the numbers in that reserve study that they're saying that you should have in your reserve account, they're flawed because everything is costing so much more money. So kind of a good rule of thumb that we're hearing from reserve companies is you should have that reserve study updated about every 3 years. Is a good suggestion. Lastly, if you're going through deferred maintenance projects and fixing things in your community, maybe even a large capital improvement project, be sure to communicate with your owners. You need a marketing plan. You need to market this to your owners, why it's necessary, why if the inconvenience is, there's going to be an inconvenience. The pool may need to be shut while we're resurfacing it. And just communicating really well with them throughout the entire process. Why it's needed, why we have to increase the assessments or levy a special assessment to pay for it or take out a loan maybe to pay for it. And then when there's the inconvenience of fixing it, making sure that you're telling everybody this is what we're doing and these are the days and we apologize, but this is necessary to make our community beautiful and keep it nice and keep our property values up. And so just having good communication with your owners throughout the process will be helpful and will limit the stress of having angry homeowners coming to your meetings, not understanding why something's happening. Last but not least, said this a couple times as we've been talking about deferred maintenance, please reach out to your trusted advisors on these large capital improvement projects. So your attorney, your management company, your reserve specialist, we are all here to help you. We're part of your team. And we want you to make good decisions as you're navigating these issues as a board member. So remember, we're here as a resource for you. We've been through this many times and we've seen mistakes that associations have made. And we want to prevent those mistakes from happening to your association because they can be costly mistakes. Okay, let's talk about our next topic, hot topic for 2024, disaster planning. This is always kind of a scary topic to talk about with associations because nobody wants to think about what if something really bad happens in our community and plan for it because it's scary, frankly, right? And so we have a really great plan that was created by the Community Associations Institute. It's a national organization that provides free information to HOAs and condominiums throughout the United States. And so they have a wonderful plan that we want to share with you on potential disasters. And, we also have a cheat sheet on insurance because obviously, how do we handle disasters that may happen in your association? We're going to be working very closely with the association's insurance company to rebuild the association if anything horrible should happen and there's a natural disaster, and this really could be anything in Arizona. It could be fires. In northern Arizona, we've had associations that have had issues with that. Could be flooding. There are fires, in-home fires, not like wilderness fires. There's a lot of things that can happen, and we've seen it over the years, and you just want to make sure that you have a good relationship with your insurance agent so that if there is a problem, that when you call them, they answer and they don't put you into some 1-800 number and, wherever the person that's handling claims is, you want to have a personal relationship with your insurance agent. So good way to do that, invite them to a board meeting, ask them to appear by Zoom, introduce themselves the next time your policy's up for renewal, ask them to look at your documents, make sure you have enough insurance pursuant to your documents, and also take a peek at our cheat sheet on insurance that our firm puts out there. We're sharing it with you now, but you also can find any of our cheat sheets on our website at mulcahylawfirm.com. Okay, so every association should have a thorough emergency preparedness strategy, and this helps as a detailed roadmap for association leaders and residents to collaborate in preparing for, responding to, and recovering from any disaster that may happen in your association. I really encourage you to look at CAI's plan for potential disasters. They ask you to start planning by doing the 5 W's. So who will be impacted and who's going to be the person that's going to respond? What disasters could happen in your community? Where do you go after the disaster? If it's something where there needs to be relocation, when should we notify residents and staff? Why have we prioritized the key response tasks? Like, what are some things that would need to happen? And then how do we get educated and prepared to react if something does happen? So a good place to start is by looking at this potential disaster cheat sheet that the CAI puts out. I encourage you to take a look at it. It's a scary topic, but it's something that you definitely want to just have on your radar and then have as a resource in case something should happen in the future. And take some time to plan. Maybe in 2024, think a little bit about what are some things that could happen and what are the plans that we would have to have in place. It's probably not going to be that difficult because we don't see a lot of natural disasters. Really, it's not something that is a regular thing in Arizona. I think probably the most important thing is having that relationship with your insurance agent and making sure that you're properly insured as a starting point. Okay, next topic we're going to talk about is electric vehicles. I put this on this list for 2024 because we're starting to see a lot of questions from boards and owners about electric vehicles. And owners are wanting charging stations and wanting to know why associations are providing this as part of living in an association. And associations also need to think about, is this something that we want to provide? Can we afford to provide it? How can we do this economically? Is there a location in the community that, we could put this if we so want to do this? This is probably what I would say more of a condo issue than a planned community issue, because in most planned communities, if an owner has an electric vehicle, they will have a charging station in their own garage. But in like a townhome or a condo community, where there may not be a garage, it becomes something that sometimes the residents are more likely to ask for. Some large master plan communities in Arizona have this for their planned communities, like they have a charging station, but usually it's the ones that have over 2,000 homes and they're newer. It's developed in the last 5 years or something like that. Associations are probably going to be faced with this problem going forward, right? Because let's face it, electric cars are likely going to be the future in our country, or at least a larger percentage of vehicles on the road will be electric vehicles. Several states have passed legislation addressing electric vehicles in communities, but Arizona has not. So you need to know that there's no law right now on the books that has been passed by the legislature requiring associations to have electric vehicle charging stations. CAI, like I said, the National Think Tank Community Associations Institute, they have some notes on this as a trending topic in our industry. And interestingly, CAI supports legislation that permits the association to enact reasonable rules and regulations concerning the cost, installation, maintenance, and removal of a charging station. And CAI also supports legislation or other public policies that incentivize associations to provide for electric vehicle charging, but also allows for the unique needs and the ability of each association to figure out what's best for them. So CAI has an interactive map that they put out, which states have passed laws addressing EVs in communities. We're going to be sharing that in the chat. But again, no laws in Arizona right now, but just kind of interesting trend to look at how many other states have laws that are mandating electric charging stations in associations. So I think it's kind of a trend that we could see going forward. Also, there's a great blog that was put out there from CAI also on electric charge. Where will community homeowners plug in? And this discusses the right to charge laws, which have been enacted by several states, including Illinois and Florida. Interestingly, the Illinois governor signed a right to charge law in June 2023, requiring that all parking spots at new homes and multi-unit dwellings be wired so that they're ready for EV chargers to be installed. I'm pretty sure the developers are not happy about that in Illinois because that adds a cost to, the cost per home. And also that cost just gets passed right through to the homeowners in the purchase price. So something to think about. A couple things I just want to mention from a practical standpoint. If you're a condo that is dealing with these electric vehicle issues, a couple things issues that have come up and that I've seen over the past few years that I thought were really interesting. So number one, some condos invest in a pay to play, for lack of better words, EV charging station. And so they have a charging station that they put on the common areas in the condo, and people, if they want to charge it, whether they're residents, or vendors even, they have to swipe their credit card in order to charge. So it basically pays for itself. Something to think about. If your association doesn't have the funding to purchase an EV charging station or EV charging things to set up a station at your association. Another thing to think about is if you're a high rise and you have parking in your association, like let's say maybe the first 2 floors or the first 3 floors of your high rise are parking, there have been some issues raised that electric vehicles are significantly heavier than regular cars. And so if you're doing any sort of structural analysis of your building, which honestly, after the building collapse in Florida a couple of years ago, if you're a high rise in Arizona right now, you really should be thinking about this issue, bringing in a structural engineer to look at your building to make sure everything's in good order and that there aren't any safety issues. Ask the consultant when they come in, can we talk about electric vehicles? And if we had X number of electric vehicles in our parking, how would that affect the structure of our building? I have one association that we work with that we talked about this extensively, and we were very surprised to learn that if a majority of the cars in the high rise were parking on a floor, that it could affect the structural stability of the building, which is something that, of course, was not on anybody's radar. And that came up as part of the engineering report that was, solicited after the Surfside building collapse in Florida. So just something to keep on your radar. If you're a high-rise association that's listening in here today, if you're doing any sort of structural analysis, bringing in engineering team to look at your building, that's something you should be asking. Okay, let's switch gears and talk about something a lot lighter, social media, another hot topic for 2024. So we have a great cheat sheet on this topic. It's called Technology and Community Associations. I do see problems with social media in associations. Okay, and here's how it comes up. Maybe your association has a Facebook page, or maybe you're having a Nextdoor page for your community. And there's a lot of bickering, let's say, on these platforms. And maybe a board member is commenting on social media. And, sometimes it could be just, that's not right, or you don't have the facts right, or whatever, but there's bickering and fighting back and forth between whoever's on the social media platform and a board member. Please, board members should not ever be commenting on social media on behalf of the board. And frankly, if you are a board member, you shouldn't be commenting even in your individual capacity, because you will be perceived as being the board member and acting as, or talking, commenting as a representative of the board. So point number 1, be really careful on social media. It's good in many ways, right? It's great getting the information out about things in your community. on multiple platforms, whether it's Instagram, Facebook, Nextdoor. All of these things are great tools for communication, but they also can go negative. And we want to be very careful that the board shouldn't be commenting on social media when things go negative. Now, if you are going to comment, the only thing that you really should say is, please come to the board meeting to discuss this with the board. We understand that you're upset about this issue. Please come to the board meeting so that we can talk about it. If you're seeing a lot of negativity on your social media, it might be a time for the board to have a town hall that talks through the issues so that this doesn't escalate into like a board removal petition or something like that. Boards should discuss internally the use of social media so that everybody is on the same page. It may be wise to create a social media policy for your boards to consider, and your code of conduct, if you have one for your boards, should address social media and not commenting on social media. We're going to be sharing with you an interesting article that we found on the use of social media by boards. I didn't write it. Founder of CAMS, Community Association Management Services, wrote this article, and he took a deep dive on the ins and outs of social media use by board members. And it's a really great article, so I'm sharing it with you because it provides valuable information on social media and some things that you may not have considered as a board or for your association. So social media is a double-edged sword. It's good in that provides information for owners. It's bad in that sometimes it can go negative and it can turn into, a lot of fighting. So you have to balance what's best for your community. I do think it balances out better for the communication, and I am in favor of using it. You just want to be careful that the board, how they handle different things that come up on social media, that we handle it in a professional manner, and we encourage people to come and hear directly from the source at a board meeting when they have questions or issues or are unhappy about something. Okay, the next topic we're going to be talking about is recruitment, how to find board members. This is always a hot topic, but I've been getting a lot of questions on this in the last quarter of 2023, so I added it to our list for today to discuss for 2024. So what do we do if we can't find anybody to serve on the board? So we have a great cheat sheet on annual meetings, and we have a little blurb in that that we're going to be sharing with you on, how to increase participation on the board, how to get board members. So here's some things that we will suggest to you. So first, the committees are a great place to recruit board members. Somebody has volunteered to serve on the architectural committee, or somebody has volunteered to be on any other committee for your association, budgeting, social committee, welcome to the neighborhood committee. This is a great place to find people who might be interested in serving on the board. So ask them, give them a phone call and ask them to be on your board. A couple other ways you can ask for volunteers to be on the board is to send emails out to your community well in advance of your annual meetings, letting them know that you put it on emails, you can put it in social media too, that, hey, we're looking for board members. If you're interested, please, follow this procedure. Keep it positive on your message. Remind them how rewarding it is to serve on the board and that it's not that big of a time commitment. Which those of us who are on the board know that at times that is not totally true. But overall, I have been on my board, like I said, for 14 years on and off over the past, since the year 2000. So I've had some time off and I've had some time on. And I would say really there were only about 1 or 2 years that were bad, right? The majority of the other years have been good. And honestly, the worst year ever was the year I was the president. So my heart goes out to every president who's listening in here today. You have a hard job, and people forget that the buck stops with you, and it's a very time-consuming job to be the president. So I get it. So if you're having trouble, make sure you're reaching out to me because I really do understand how difficult it is to be president. I can give you some good advice and solutions on how to manage that year or years if you do it for multiple years. Okay, what do you do if you've done all these things? Like you've gone to committees, you've talked to people who come to your board meetings to see if they're interested and they're not. You've advertised and sent out emails and you still can't get anybody to volunteer to be on the board. The last step is a letter from our firm. This is what we suggest to our clients that can't get anyone to run for the board. And I can tell you that I have never sent this letter where we didn't get board members to volunteer. Basically, the letter is scary. It says that the association's board has contacted me because we have vacancies on our board that we are unable to fill. Nobody is willing to run for the board. And therefore, we have a situation now where we don't have a quorum of the board to conduct business. And the implication of this is there's going to be a receiver appointed to run the association because we don't have board members to do it, a quorum of board members to do it. And how that works is that we petition the court, Superior Court, for a receiver. They appoint one. It's very expensive. I've seen receivers be appointed by a court. It's $80,000 typically. If you have a larger association, maybe it's $40,000 if it's part-time. Receiver for a smaller association, and the judge just rules right then and there, okay, special assessment to everybody to pay for this. And when I explain this in the short letter that I send out, and I ask, this is our last call to ask, is anybody willing to run for the board? People step up. They don't want a receiver for a number of reasons. A, it's more expensive. B, it's definitely not something that is good for resales in your association because it's going to have to be disclosed to any buyer, and it really could affect your property values. So that's kind of your last effort. If you're an association that's in that situation right now, reach out to our firm and we can show you the letter and help you get the word out to your community that this is unfortunately what's going to happen if we can't get a quorum of board members to run association business. Okay, a couple more topics. One topic that I want to just talk about quickly that I didn't put on the agenda for today, but I think is important to discuss is water in Arizona. We spent some time in other classes talking about the fact that the Arizona Department of Water Resources is in a management plan right now for limiting water for certain associations. And you will be receiving a letter if your association is one of those associations that has a lot of turf. And they will be asking you to comply with the water restrictions that the state is putting in place. If you have that occurring in your association, like you received a letter from the state of Arizona on this, there are resources for you to help you manage this issue. There are companies that come in and help you determine how to reduce the amount of turf that you have so that you can comply with the water restrictions. There are going to be further restrictions down the road. So this is something for associations that have a large amount of turf. You may want to reach out to our firm to get some advice on how you can pre-plan for that. I've attended a couple seminars where there are companies in Arizona who this is what they do. They advise, large landowners how to comply with the new restrictions that are being put in place by the state of Arizona. So we can also point you in the direction of those entities to help you manage the issue as the state continues to regulate the amount of water usage. And this really is only going to apply to the associations that have a large amount of turf. Okay, next and last topic we're going to be talking about before we go into our Q&A is artificial intelligence. And so we're hearing a lot about this on the news. How might this impact associations in 2024? So something that you might be hearing about a lot is this Chat GPT. I encourage you to Google it and find out more about artificial intelligence. But how could this impact our associations, right? HOAs and condos in Arizona. So what is AI and how is it going to impact our industry? Simply put, AI, artificial intelligence, enables machines to mimic certain aspects of human intelligence, such as problem solving, learning from experience, and adapting to different situations. So it's a technology that aims to make machines smart and then allows them to analyze data, understand everything that's coming to them in the form of a question, and then perform tasks in a way that simulates a human on the other side. So in preparing for this presentation today, we came across a couple of articles on artificial intelligence and how it may help management companies by improving productivity and efficiency down the road. And so some ideas that, we saw in these articles were that artificial intelligence could help with communication to members. So let's say that a member calls in with a problem, they could have artificial intelligence responding immediately to the owner. So maybe, something that I hear at annual meetings often is, I called the management company and they didn't call me back, or I called the management company and they didn't call me back for a week. Having this artificial intelligence capability for the management company could involve better communication to the owners when there's a problem. Some other areas would it could help predict maintenance schedules, also could help with replacement of different appliances, et cetera, within an association. It's just something to keep on your radar for 2024. It was a buzzword for sure in 2023. And now we're kind of all trying to react to how is this going to impact our industry and how is it going to be helpful? There are some scary parts of artificial intelligence, right? Like voices can be recreated through artificial intelligence, and it could be used, to potentially harm the association in some way. So it's scary. Of course, it's scary, like anything new technology that we don't understand. Trying to keep our finger on it and understand how it may help us, and then also making sure that we have safeguards in place as an association so that artificial intelligence can't be used in any way to harm the association. And so it's a new topic. We're going to be looking into this more in 2024 and likely bringing these issues up in the classes that we teach. If we hear of anything in our industry that might be helpful, or that's something you need to keep an eye on to make sure that you protect your association. Okay, one thing that comes up with AI is it going to lead to people losing their jobs, right? So are you not going to have a management company anymore? How is that going to impact boards? A board even need to be in place anymore? Will the board be artificial intelligence? I doubt it, in the next decade that we're going to see anything like that. But it's kind of a fun thing to think about, because that obviously could decrease the costs for an association, which should be helpful for an association, but it also would take away the personal touch that I think is really important in running an effective community. So we'll be talking about this for sure in the coming year and in future years. Okay, so we kind of got through all of our hot topics for 2024. I did it in 57 minutes. I can't believe it. Great start to the new year. Right now we have 27 questions, and how it works if you're joining us for the first time is we finished our official presentation, and now I'm going to be going into the questions that have been presented for today. Okay, our first question. Barring any legislative rules to the contrary and no restrictions in the community documents, can an HOA, Condominium Associations Board, approve and declare and impose a secret ballot, i.e. restrict members from determining how other members voted for any community-wide vote, such as an election or a special assessment? Okay, so let's talk a little bit about secret ballots. So you are required to have a secret ballot if your documents require you to have it. Okay, so typically we see it in the bylaws. Usually it's in the annual meeting section where they talk about directors are elected by a secret ballot. Sometimes it refers to other things as well, like any vote taken by the board, by the association, a secret ballot. So what do you do? I'm not quite sure in this situation so it looks like, obviously in Arizona, there's no requirement to have a secret ballot. Okay, so you should know that up front. In your association, you're saying that the documents also do not require secret ballot. So there's kind of two ways to cut this. So maybe your board is thinking about using a secret ballot. They have a choice to do that as a board when they're voting on something. In my experience, over a quarter of a century experience, most boards would not voluntarily, most meaning 99% of boards, would not voluntarily choose to make a ballot a secret ballot. Okay, the only ones that are doing it are required by their documents to do it. So that's important to note. Why do they not want to do it? Because it's a huge hassle. There's a couple reasons why it's a hassle. Number one, to put the ballot together, it's more complicated. You have to have a double envelope system so that the ballot is in an envelope that doesn't have any identifier on it to identify who's voting it. And then the second ballot has the identifiers on it, and they're separated at the time, that the ballots are opened. So there's a cost to doing it, and it's harder to do it that way. The other reason why people don't like doing it as board members, having it for your community, is because people get the ballot and it's difficult, right? People don't know. They think that the ballot had a mistake. Why isn't there a place for me to sign? Why isn't my unit number on here? And lots of times people don't fill it out right, and they put the identifier on it, which could potentially invalidate the ballot. Short answer on this would be that most associations are not choosing voluntarily to do a secret ballot. They're only doing it if they have to. The other side of this is, okay, let's say that you had a ballot that wasn't a secret ballot and the board doesn't want to share who voted how on the ballots. There's really no way around that. If the ballot is a record of the association and you have the records, you have to provide those records to an owner if they ask to see them. That's just how it works. So I hope that answers your question. Most boards are not using secret ballots unless their documents require them to do it. And if somebody wants to see how ballots were voted and they weren't secret ballots, the board has to provide that information after a written request for a records review of those ballots. Question 2, to what extent, if any, are proper minutes for an association meeting different from those of a board meeting? For example, are association minutes approved by the board or by a vote of the members? As with board meetings, are association meeting minutes limited to member actions and votes, not what members or guest speakers say? Okay, so there's a good distinction on this. So this question is asking me to make a distinction between regular board meeting minutes and meeting of the membership meeting minutes. So example, like the annual meeting minutes or a special meeting of the membership to vote to remove a director, or a special meeting of the membership to vote to levy a special assessment. We're looking in this question is, how are they different? Regular meeting minutes are reviewed at the very next board meeting. For example, let's say our December 2023 regular board meeting, we took minutes, and then at the January 2024 board meeting, we review those minutes as a board and approve them right then and there. Okay, so you do it right after the meeting, month after, typically if you have monthly meetings, or if it's quarterly meetings, at the quarter after. The board reviews and approves. Membership meetings are a little bit different. So like your annual meeting or like your removal meetings of a board, etc., those are approved at the next regular meeting or the next meeting of the membership. So for example, if you had your annual meeting in December 2023, you will not have the membership approve the annual meeting minutes until December of 2024 at your next annual meeting. So you wait a whole year to approve them. That's it's unusual, and I get a lot of pushback often from people like, that doesn't make sense. That's a whole year. Well, it does make sense in that the only people that can approve those meetings minutes are the members, because it's a members meeting. So you wait until the next members meeting. Same thing, like let's say in between the annual meeting, you have a removal meeting of the board, right? And at the next annual meeting, you should also approve those meeting minutes because that's your next meeting of the membership. How are they different? I recommend that you take a look at our cheat sheet on board meetings, how to run an efficient board meeting, I think it's called, perfectly proper board meeting. On the flip side of that, we have how to take perfectly proper meeting minutes. The meeting minutes are the same for annual meetings, meetings of membership, or board meetings. Basically, keep them short, and it really should be what was decided. Was there a quorum? Who attended? What was decided by the board at a board meeting, or what was decided by the community members? You can put a short sentence like there was a treasurer's report, and explain the finances of the association. That's fine, but you don't have to go into detail on it. If you want to make an attachment like the financial statement or the budget, you can attach that to the meeting minutes. That's fine. And so I think that pretty much answers it. So how are they different? I explained that. You don't really want to go into in either set of minutes a long diatribe about what somebody said. It's what happened at the meeting is the most important thing. Okay, next question. What happened, meaning what vote was taken and decided at that meeting, whether the vote failed or whether the vote passed. Okay, next question, number 3. Are HOA CC&Rs prohibit RV parking anywhere in the association except when loading or unloading from a trip? But the CC&Rs do not define RV. This has led to arguments from a couple of members that their RVs are not RVs, but are cargo vans or even storage vehicles. The board is planning to write an amendment to the CC&Rs prohibiting parking on the lot of any vehicle larger than a specified size. Vehicles other than RVs would now fall within the restriction, including larger trucks. Existing owners of such vehicles would be grandfathered in. Trailers and boats are already prohibited from being parked on member properties and will still be prohibited in the new amendment. Is this a workable solution? So you want to write an amendment to the CC&Rs being more specific about defining RVs. I think that would be fine. It looks like you want to expand it to some other larger vehicles too. Just remember that you're going to want to get advice on the language for the amendment. And we're also going to want to look at the amendment and as to whether or not this is foreseeable and reasonable under the Callaway case. So I would suggest you reach out to our firm, but based upon what you told me here, everything looks like you're moving in the right direction and I'm not opposed to it. Okay, number 4, how likely do you think HB 2270 will pass? I'm specifically interested in the requirement to supply a meeting agenda with the announcement of a board meeting. This is a new bill that has been introduced in the 2024 legislature, and it covers a lot of topics or wide range of topics, ranging from open meeting exceptions to remote meeting technology and posting notice for meetings. You're talking about page 7 of the bill, which states, it says at least 48 hours before the meeting and may be revised as required by the board president or committee chairperson to add or remove agenda items based upon the developments since the draft was issued. If the meeting agenda includes proposed approval of an annual budget or a policy or rule, that proposed budget, policy, or rule shall be posted along with the notice of the meeting. How do I think it's going to pass? I never know at this stage, right? Really, we have already been advising associations that they should be including an agenda with their meeting notice. We've been advising them to do that for a couple of years already because there was legislation a couple of years ago that talked about if you're doing a bylaw change or a rule change that you needed to indicate that you were doing that in the notice. I'm not opposed to having the agenda, state with particularity what that rule change would be if this law would pass. So I am not opposed to it. I think it's good. We want to be transparent. We want people to know what's going on in the community. Is it kind of a hassle to do this? Yes, because sometimes things change, within 2 hours before the meeting. Sometimes the agenda is changing. How likely do I think it will pass? Sometimes with legislation, you have to see it introduced a couple of times before it actually gets legs and gets passed. So I don't think this particular part of it is likely to get passed, although it could be considered like an extension of the bill that was a couple of years ago. It just further defines it. So maybe it is something. We'll have to wait and see. But I'm not opposed to it if it does pass. I think it's probably something that would be helpful to the owners. Okay, next question, number 5. And I want to say thank you to my team because all these new bills were just introduced in the past week. And for them to get that to get the exact language for me and to help me answer this question, I really appreciate my team. Good job, team. So thank you for doing that. Okay, number 5, what liability would a board or homeowner have if volunteers who are not licensed, bonded, or insured do work, such as electrical repairs, cutting down trees, if that volunteer becomes injured, or if there is something that happens to someone else because of the work that they have offered? What liability do we have? We have a great blog that we've put out there on Be Wise when it comes to volunteers. And so I want to encourage you to take a look at that. We're going to be sharing that with you on Zoom and Facebook Live. Also, you can find it on our webpage at mulcahylawfirm.com under our blog tab on our homepage of our webpage. Okay, so there's a lot of liability, actually. Depends on what work the volunteer is doing, right? But electrical repairs, cutting down trees, that should never be happening by a volunteer, ever, okay? Those are tasks that you need to be bringing in licensed and bonded contractors to do the work. Sometimes if you're having, volunteers, something that maybe would be more acceptable would be like a community-wide trash pickup where, we spend a Saturday morning, and everybody looks for trash in the common areas and then we have coffee and donuts at the end. Or maybe changing a light bulb that does not require you to get on a ladder. I've kind of done all those things as a director myself. Where you get into dangerous territory is where you have a volunteer doing tasks that are, really required to have somebody who's licensed and bonded. And then they get injured. Well, what could happen there? I mean, there's lots of things. We could be sued and have to pay their medical bills. They could be considered under workers' compensation, even though we're not paying them. We may have to pay their medical bills. So I would very much encourage you not to do that on these type of tasks where, you need to have people who have some expertise and it's inherently dangerous. there's all kinds of liability here. What if they do electrical repairs and then ultimately it causes a fire or somebody gets electrocuted? There's liability for the association right there. There's an accident, now we have liability for whatever harm is caused to the person. The board can be sued for breaching their fiduciary duty to the corporation and their duty of care and not hiring licensed contractors. So just be really careful on something like this. There's a lot of liability, and I am the first person to encourage boards not to have volunteers doing tasks like this. Okay, question number 6. I have hearing and visual problems, and I'm 79 years old. I have requested attending a board meeting by sitting within the boardroom in our clubhouse. I have been told no, it is only a Zoom meeting. Several have requested that the meetings be recorded so they could be listened to, though, by those unable to attend or re-listen to for clarification. The board has absolutely refused to allow this to happen. What are your feelings on this? Okay, a couple things. Most boards now, truthfully, are having meetings by Zoom. That is just the norm. I very rarely do I now attend meetings in person. Most boards prefer to have me attend by Zoom, and most boards prefer to conduct their meetings by Zoom because owners prefer it and they get a wider cast of people who can come. For people who are in Wisconsin or Michigan or Minnesota in the off season, they can still participate by attending by Zoom. Okay, but you have a special situation here where it sounds like you potentially have a disability under the Fair Housing Act, and you want to come to the meeting and sit with the board in your clubhouse because of your hearing and visual problems so that you can listen in person in the meeting. I'm assuming that your board is meeting in person, but then everybody else comes by Zoom. Okay, so I think under the law, under the Fair Housing Act, I think the board does have to make a reasonable accommodation for you if you can provide a letter from your doctor stating that you are, required to be there in the clubhouse and why. It has to be directly related to your disability. So one workaround would be is if they don't want to have you in the room with them for whatever reason, because COVID's going around again and there's a lot of illness right now in Arizona. There's different factors. They should try to make a reasonable accommodation some way to make it easier for you to hear what's happening at the board meeting. Maybe we are required to provide a recording as a reasonable accommodation, meaning the board, record the board meeting. Or maybe you should be allowed to record it. Under the law, just you are required to, or you are allowed to record any board meeting. If a board has a policy regarding recording board meetings, you just have to follow that policy and notify them that you're recording it. So I think that we need to have, the board needs to be aware of the requirements under the Fair Housing Act. And I don't know if your hearing and visual problems are considered a disability on the Fair Housing Act. I'm assuming they probably are. And if you get a letter from your doctor, they're going to have to make a reasonable accommodation for you. Okay, next question from one of my favorite former board members who's a homeowner in an association. Great to see you here today. Our HOA organization recently hired a new management firm. Numerous written requests for minutes have been ignored. What are some suggestions for resolving the problem? Okay, so you've made written records requests to the board for records. I heard you have a new management company, so I'm sorry that this is happening to you. This obviously should not be happening. You're asking for regular meeting minutes. I'm assuming you know that you're not entitled to executive session meeting minutes as a homeowner. What I would do is just send one final letter stating that I know that there's been some changes recently at the association. You may have missed my records request. Send it directly to the board and to the new management company and say, I'm sending you this final reminder that you have 10 business days to provide me with the following records, and then list what exactly you want to see. If you don't comply with sending me these records by X date, I plan to, and then you have a number of options. So you can hire a lawyer to help you get the records. You can go to the Arizona Department of Real Estate and for $500 file a complaint against your association, and then an administrative law judge will conduct a hearing as to why you're not getting the records. That probably will be a quick way to get their attention. You can file a lawsuit to get the records. If it's important enough to you, to expense to do that, you can file a lawsuit. You can pick up the phone and call the board member if you know anybody on the board and say, hey, I don't understand why my requests aren't being responded to. So those are all the different options that you have, in this situation. Maybe they have them on their website. I don't know. Maybe check to see that they're not readily available somewhere online that you can look at them. Okay, question number 8. Is there a hierarchy for all the state and federal laws for HOAs? Really good question. So I wish I could say yes, and there was some really easy rule, but there isn't. So, typically the federal laws, they're not conflicting with the state laws. I can't think of really any examples on this. Maybe so the satellite dish laws that went into effect in 1996, allowing owners to have, a 39-inch or less satellite dish on their property, which is kind of outdated now. No one's really using those anymore. That trumped anything in your documents that said no satellite dishes, right? So that federal law would trump your association's documents. But the federal laws that are on our radar now are the Corporate Transparency Act, the OTARD rule, which deals with satellite dishes and antennas, the Fair Housing Act. If you're an association as a place of public accommodation, like a public restaurant, the Americans with Disabilities Act, there aren't really that many federal laws that are out there that apply to us as an association. Now, state laws, it just depends on how the state law is written. So sometimes it says in the state law that unless provided otherwise in your document, do this. If it says that, that means your document controls. If it says notwithstanding anything in your documents, that means state law controls. So you kind of have to look at every single statute to see if it trumps your documents or not. So I wish I could give you a bright line rule. I can't. But if you ask a specific question like, does this state law trump what our documents say? I can tell you specifically whether it does or not. Okay, question number 9. If the board doesn't respond or if the community is successful in removing an entire board, what happens next? Okay, great question. So you're talking about the new law that went into effect on October 30th, 2023 about board removal. So let's say the board doesn't respond to the removal petition within the 30 days. Basically what happens is the law says that the board is automatically removed. So what is the next step? And it's the same next step if the board the homeowners have a meeting and the entire board is removed from office, right? It's the same next step. We have to send out communication to the membership. Usually the attorney and the management company, if you have one, will assist with this. So there's no board in place in this situation. And we have to solicit volunteers to be on the board. We have to send out a notice of meeting, and we have to actually conduct a meeting to elect new board members. Hopefully that answers your question. Number 10, HR 2084 proposes to strike 33-1804, the ability to give notice of meetings via pamphleting via delivery to each unit, and requires the person notice or delivery to registered email or address. In case of lethargic or uncooperative boards and management, wouldn't this change inhibit the members' right to call a meeting to conduct business, including recalling a board, as members do not have access to the registered contact info and rental units do not allow for in-person contact to assure notice of 100% of members as required? Okay, it's kind of a confusing question for me. So let's see. Not sure exactly what you're asking. So you're asking about HR 2084, right? And I'd have to actually look at the same statute at the same time. So let's move that to the end of the presentation, and maybe somebody on my team can pull that up for me and I can look at this. Okay, question number 11. Is there a differentiation between snowbirds and year-round residents for short-term rental amendments? There shouldn't be. I guess this is a tough question for me to answer because I'm not really sure what you're asking. So snowbirds are traditionally kind of defined as maybe November to April. So I'm wondering if you're saying is there a special exception carved out for snowbirds because it's like maybe 5 months and versus year-round residents for short-term rental amendments? Maybe you're saying that snowbirds own and can they short-term their property when they're not there? Really not sure what you mean by this question. I'm sorry. I wish I understood it better. I think probably the bright line rule on short-term rental amendments is they're uniform. They apply to every unit or lot in the same way. And so there shouldn't be a differentiation. If you have a short-term rental amendment in your documents, your board needs to follow it. Okay, question number 12. Can an HOA board of directors make changes on the community bylaw, such as board of director terms limit, without a vote from the homeowners? So it really depends on what the amendment section in your bylaws says. If the amendment section says that the board has the right to amend the bylaws, then yes, they can. Again, we got to go back to the notice requirement. So the notice of the meeting, the current law says that if you're doing an amendment to the bylaws, you just need to notify the membership in the notice that you're doing an amendment to the bylaws, so that if members want to attend, they can attend that meeting. Okay, number 13, our HOA clubhouse is being used weekly for a poker game that has a $20 buy-in. Not all the players live in our HOA. Does gambling create a liability issue for the HOA? I've seen this issue come up, and same thing with bingo, like there's a buy-in for the card on bingo or whatever. I'm not a gaming expert by any means. You may want to contact the state of Arizona anonymously to see, is there an issue with this? I am not sure it is an issue because it's, I'm assuming that there's a resident inviting people to come in. It's not like some 100-person game or something like that where you are doing that. It's probably just, a small group. And I'm guessing that all the money gets distributed at the end to the winner. So I don't really know the answer on that. I don't think it does, but you'd have to check with the state to be sure. Okay, next question. What is the statute of limitations for an estate or trust for a deceased person? A claim has been submitted to the HOA board for estate or trust from 2019. I'm not really sure what you mean by this. So is it the statute of limitations to get the estate to pay for a debt that's owed by somebody that's a deceased person? I don't know. So I think that may be what you're saying. So we have 6 years to sue any owner for an unpaid debt. I see a claim has been submitted to the HOA board for the estate or trust from 2019. I'm not sure what that means. I'm sorry. This is a good example of I want to help you, but I don't understand your question. So maybe circle back on our first Fridays and clarify. Okay, question 15. We are a very small HOA whose only responsibility is to manage the water well system and periodically grade our dirt roads. We are abiding by the public meeting notification requirements. Are we also required to follow Robert's Rules of Order at our meetings? We have a member of the board that insists that they be followed to a T. You're not required to follow Robert's Rules of Order unless your association documents require it in the face of the document. So it says all board meetings must be conducted pursuant to Robert's Rules of Order. I'm really not in favor of following Robert's Rules to a T because this is like a 13-volume book that has all kinds of parliamentary requirements. And I'm not even a parliamentarian, right? What I suggest you use Robert's Rules of Orders for is on one of our cheat sheets. I think it's our board meeting cheat sheet. We give you suggestions on how to comply with Robert's Rules of Order to help you run your meetings more efficiently. So what I would say is you could take a couple points from Robert's Rules of Order. And remember, it's a 13-volume book. So very few things, simple, easy ones, only talk about, one thing at a time, right? And the chair recognizes who is talking. You can use that effectively if everybody's shouting and screaming over each other. The chair creates order and says, you are allowed to talk, and then backs out and then another person's allowed to talk. So there are some good points to it to help you manage meetings if you have kind of a dysfunctional meeting environment, but it's not something that I would recommend that you follow to a T. And if it is in your documents, I would amend that out. Okay, question number 16. What downfalls should an association look at before borrowing over $1 million or long-term debt? Whenever an association is looking at taking out a loan, there's a number of different factors that come into play. So, number one, I'd probably be working with your association's attorney, right? And make sure that you have the legal authority to do this under your documents. You should be carefully evaluating whether taking out a loan is the best thing to do for your community. Some associations finance big projects through partial loans, and then they fund it through a special assessment or increasing the assessment rate. Some associations take the full loan out and pay it over time. It really just depends. I think what I would do is just that this should be discussed with your attorney and make sure that you have the legal right to do this, and that you've thought through the financial implications, such as interest, and that you understand if you default on the loan, that typically the collateral is the incoming assessments, the future assessments. But a lot of associations I'm getting loans in the 27 years I've been practicing. Fewer now because interest rates have been so high, but they're going down. So maybe we'll start to get these questions again. I wouldn't say that the downfalls would probably be the interest, and you have to repay it over time, and you have to explain to the membership why this is necessary. But as long as you have a good reason for handling it this way, I'm not opposed to it. Just make sure you get legal advice so that you do it correctly. Okay, question 17. We live in a zero lot line community. There have been disputes about who owns the easements and how to access an easement to maintain a party wall. Should the property manager and board members understand these matters to serve as a resource if property disputes arise? So yes, these are complicated issues. I have seen a couple of these in the last quarter of 2023, and I had to reread the provisions like multiple times just to make sure I fully understood what the intent of the drafter of the CC&Rs was trying to do. So zero lot line communities with access easements to maintain a wall that may be on somebody else's property. These are complicated issues. So yes, the board member or the property manager should, do their best to understand it. But the reality of the situation is maybe you need to bring in your trusted advisor, attorney, to help go over the issue with the board so that everybody understands it and is on the same page, because these are complicated issues. Okay, question number 18. Does Arizona law require that a chairperson for a committee need to be a board member? So yes, there's one committee that it is required that a board member chair it, and that is the architectural committee, and that is right in state law. If you want to take a look at our cheat sheet on committees, or I think we also have one on the architectural committee specifically, go to our website at mulcahylawfirm.com and look at our cheat sheet on it. Question 19. We are 56 unit COA in Sun City. Is it a law that our landscaper has to have a ROC license, or is it just good practice? If a law, can you give me the state number? So we have a great blog on this topic called It's Worth It, Hired, Licensed, and Bonded Contractor. We're going to be sharing it with you on Zoom and also on Facebook Live. You can also find it on our website at mulcahylawfirm.com. So ARS 32-1151 sets forth Arizona's contractor licensing requirements. A couple things to think about. If the job amounts to less than $1,000, it could be that there is an exception. But for landscapers, it's my understanding that they have to have a license with the registered contractors if they're doing any sort of irrigation work. So what I would suggest to you is that you first ask your landscaper, do you have a license, ROC license, registered contractor's license? If they don't, you may want to call the registered contractors and explain specifically what the landscaper is doing for your community and determine whether or not they need to have a license. Now, anytime you have a landscaper coming on your property, they really should be insured and bonded. And, 99% of the time they are doing irrigation work if they're a landscaper, so they should be licensed too with registered contractors. Okay, question number 20. As opposed to many other states, Arizona Condominium Act statutes are lacking or absent in articulating member interests and fiduciary duties owed to members. It appears boards then defer to the Nonprofit Corporation Act to determine fiduciary duty obligations. This does not protect owners' investment interests. Question, how might an association go about creating an amendment to their CC&Rs and bylaws so as to articulate some form of beneficial interests or fiduciary relationship? Honestly, I don't think that's necessary. It's right in the Nonprofit Corporation Act, the fiduciary duty that a director owes to the corporation. It's the duty of care, duty of confidentiality, and the duty to avoid self-dealing or conflicts of interest. Almost every association in Arizona is a nonprofit corporation, so this law applies to you. If you want to go above and beyond and put it in your CC&Rs or bylaws, you certainly can do that by amending your documents. However, it's not something that I have seen anybody do in Arizona. And, we work with thousands of associations. Okay, question 21. Is there an Arizona statutory definition of townhouse versus condominium? And does it matter if the HOA homeowners own the real property, but are referenced as condos in the bylaws and rules and regulations? So this is a good question. This is kind of unusual in that Arizona does not legally recognize townhomes. So in Arizona, you are either a condominium or you are a planned community. Townhomes are kind of like it's like three circles, right? Townhomes sometimes can be in the middle, and some of them may be condos and some of them may be planned communities. It really all depends on the definition section in the townhomes. Like if the townhome association owns the common areas, typically they're going to be a planned community. If it's a townhome and the individual owners in the townhome own a percentage interest in the common areas, it's going to be considered a condominium. So your question is, does it matter if the HOA homeowners own the real property? That means typically you're going to be a condominium. And then you're saying, but are referenced as condos in the bylaws and rules and regulations. I mean, that's legally proper, because if the homeowners own a percentage interest in the common areas, it's technically going to be considered a condominium. So if you have any questions on this, reach out to our firm. We can look at your documents and tell you specifically what your association is. Question number 22. Can the association legally limit the number of group homes within the association's boundaries? So we have a great cheat sheet on this. It's called Federal Laws for Community Associations. The Fair Housing Act is a federal law that applies to condominiums and planned communities. So can the association legally limit the number? My answer to that would be no. The city, town, municipality, or county may have limitations based on how many can be in a certain geographic area. So you may want to check in with them to determine if they have any for the association that you're asking about. In my experience, it's usually there's plenty allocated under the local governments. So we've never successfully been able to limit the number of group homes within an association's boundaries. In my experience, that's going to be really difficult to do, but check with your city, town, municipality, or county to see what their restrictions are. All of these group homes do need to be licensed through, the city, town, municipality, or county. So they will have the information at their fingertips, but associations cannot do that. Okay, next question, number 23. And I'm just going down to the end. It looks like we have 33 questions, so we're getting close to the end. Are there any programs in Arizona that could help the lower income association with major repairs through low interest loans or grants? Yes, absolutely. So whatever city that you live in, you should be checking with them because they do grants every year. Now, the cities are typically operating on budgets that will start July 1st. So you're halfway through the year right now, more than halfway through the year. Check in with the neighborhood services department of whatever city that you live in, and they have grants in place. You can apply for one. I'm not aware of any low interest loans, but I am aware of grants that the cities provide. It's not 100%, but they will pay a portion of the grant, sometimes up to 50% for certain projects. Question number 24. Can an HOA require an owner to seek architectural approval before installing a charging station in their own garage and provide proof the electrical service is able to support it? I'm not entirely sure on that. I don't know if your garage has like a door or if you're a townhome or what's the situation here. I probably need to find out more information, or if you share walls with somebody else. I don't think that it's unreasonable, and probably should be pretty easy to do because however you're installing it, you're probably using somebody who's qualified to do this, or maybe it's just a machine that you plug in the wall. I really don't know the logistics of how it works. So I'm not sure if they can require it. I'd have to look at your documents specifically, but I'm not opposed to it because we certainly don't want to have a fire, right? But if it's not something that falls under the rights that they would have under your documents, you may be able to challenge it. But I'm kind of sitting here thinking, why? You don't want a fire either. So it seems to me like it's not that unreasonable of a request. Okay, number 25. We live in a condominium complex. Each unit has its own garage. How can we monitor to ensure, another one on this, to ensure an owner does not install an electric car charger in the garage without the HOA's knowledge? It may be unsafe and overload the building's electrical capacity. It's kind of funny. Sometimes I used to write a column for the Arizona Republic many, many years ago. It's like 20 years ago now. And occasionally when I was writing the column for the Arizona Republic, it was called HOA Q&A. The same day I would get a question from owners in the association and the board, and I would be hearing different facts. So it was always challenging on how I responded to it so that I didn't get a bunch of screaming people yelling to the paper that I didn't have my facts right. So it's interesting that the question right before here has somebody asking, do we have to get architectural approval? And then the very next question is, it's a condo. Okay, so that was one of the things I said when I answered the other question. I don't know enough about your association's documents, but I do think in a condo complex that this is something that the association could be involved in, because I'm not sure that the garage is considered part of the unit, and we want to make sure that these things are a safety issue. So I'd have to see the documents again to give a formal opinion on this, but it doesn't seem unreasonable. But to give a formal opinion, I think I would need to see the documents. Okay, question 26. Do you recommend an HOA requiring a homeowner to purchase a host liquor liability policy if they are hosting an event in a common area where alcohol will be provided by the homeowner? So great question. So somebody's having a party on your common areas. I would check with your insurance agent to see what they recommend. I know my association where I live that we do have to have a policy. Typically, it's just our actual homeowner insurance policy for the home is something that we can just provide, and it's sufficient. Copy of the policy being in place. Your insurance agent may say, yes, they do need a special one-day permit. I mean, it just depends. I mean, if you're having, like some ladies over for bridge and you're going to have one bottle of wine and 8 people are drinking it, I mean, I'm not sure that that's something that you're going to need to get the insurance, right? But if you're bringing in the Miller beer trucks and you're having a block party and it's going to be a little nutty, then that may be something where we want to have that policy in place. So check with your insurance company, get more information about what the event is going to be, and then make a decision. Number 27, the latest move against the open meeting law is to have the board approve authorization for the president or management accounting to $3,000 to $5,000 to cover unknown expenses like projects, maintenance, travel, and education. Is such an arrangement really legal? So I think what's happening here is the board pre-approves authorization for the management company or a board member to spend money in the event something should happen. I'm not opposed to this because things do come up in the summertime, especially like, for example, pool pump breaks. And it's hard to get a quorum of the board to make a decision. So maybe in advance, they say any directors or the management company is entitled to spend up to $5,000 for an emergency. I'm fine with that. Education type things. Maybe there's classes that come up where the manager or board members want to take a class and it's last minute and there's a cost for it. I'm fine with that. I mean, just as long as it's in the minutes of the meeting and the number is reasonable, I'm totally fine with that. Question 28, regarding community perimeter walls. One thing I want to make clear is that if they do cover an unknown expense, I think it would probably be a good idea just to notify the board at the next board meeting, okay, these unknown expenses we spent money on these last month, so that there's paper trail, so that there's not just like, blank check. And we spent this over these months, and ask for approval after the fact of that as well. Okay, next question, number 28. Let's see. It's like we have about 7 more questions. Regarding community perimeter walls, one got blown down in a storm. HOA board has not checked with legal on repair, and homeowners insurance says it is the HOA responsibility. Yet the board refuses to see if the HOA is responsible. Who can the homeowner go to? Okay, this is a serious issue. So if you have a perimeter wall that was blown down in a storm, that needs to be addressed immediately by your board. Also, if the wall was so structurally unsound that it was blown down, I think the structural integrity of the entire wall should be looked at to make sure that there's not other issues. So, the board really does need to get their legal counsel involved, and they need to get moving on this. They also maybe need to check to see if the insurance might cover it, because sometimes like an act of God like this, where the wall gets blown down, might be covered by the insurance. And the longer we wait, the more likely it is that it's not going to be covered. So I guess what I would do if the board, isn't doing anything, or you're claiming the board isn't doing anything, what could you do? You could write an email to the association's attorney asking them to look into it. You could write an email to the insurance company for the association asking them to get involved or to contact the board to look at it. Before you do that, though, make sure that you attend a board meeting or you write a letter and make sure that the board receives it so that you're not going around the board. You want to give them ample opportunity to look into it. And if they're blowing you off, then you take those other routes. Okay, number 29. Do you have an example or template for a social media policy? I don't, but I do have a board code of conduct. I'm not sure if I have anything in there on that. I think I do, but what I would do is take a look at our cheat sheet on Board of Directors Code of Conduct. We have sample language in there, and you can find that on our webpage at mulcahylawfirm.com. Really, all you need to say is that board members should not be moderating any social media pages. So board members should not be the moderator on anything. That is inappropriate for a board member to be moderating a social media webpage or whatever, Facebook or something like that while they're serving on the board, because it could be perceived that this is now the board's platform. Also, board members should not be commenting on social media. I think you could just put those two things in my Board of Directors Code of Conduct and you'd be fine. Okay, question number 30. Can the board hire a full-time management without consulting and asking the HOA? So, good question. Probably yes, they can, but you'd have to look at your documents. It is a board decision in my experience, and usually the board does make that decision without asking the HOA for their approval. The board should have good communication and be transparent with the homeowners. If they're doing this should be discussed at a board meeting. The reasons and the rationale for going to full-time management should be conveyed, and they should be seeking input, before they do it. So short answer would be I'd have to see your association's documents, but yes, generally speaking, they have the right to do that, but they should also be communicating well why they're doing it and the costs and, how it's going to be beneficial. Okay, we are down to our last 4 questions. As a board president, how do I change landscapers and or a management company? My HOA has approximately 2,200 homes. Okay, so in terms of changing landscapers in a management company, as board president, you're a leader of your board. You just need to start documenting what the problems are, right? And you need to get a majority of your board to agree with you. And so you can talk about performance during executive sessions where it's just the board and you don't have to invite the management company. Obviously, you don't have to invite the landscaper. If you have an executive meeting like this, it has to be noticed 48 hours in advance. If you don't want to have an executive meeting because you don't want to warn the management company that, hey, we're thinking about firing you, the board president can go and talk to other board members, less than a quorum, about your concerns. And then you can talk about it at a board meeting. You can talk about it in an executive session. I would recommend that you reach out to our firm or your lawyer because you want to look at the contracts for both of these entities to determine how to terminate the contract with the landscaper or the management company. And you want to have a plan in place. So you're going to want to, be interviewing new management companies, new landscapers. There's a whole process for this. We can help you with it. We have a sample RFP, your request for proposal, you can send out for the management company. But you definitely want to reach out to our firm or your lawyer and talk about it. We have a great cheat sheet on selecting a management company. So after you get rid of the management company, finding a new one, that we have the cheat sheet on our website on that. But thought and planning needs to go into this, and also some strategy, because sometimes issues come up when you fire the management company and you want to pre-think it. And you also want to pick a company that's going to be good, that's going to be a good fit so that you don't have issues going forward. So reach out to our firm. We're happy to help you with that. We've been through that process many times, and I think we can give you some good tips. Last 3 questions. Any advice for a transition team from builder, developer to owner, or a new board when little or no assistance is received from the association or builders board? You bet I have advice for you. You definitely need to check out our cheat sheet on transition from developer to homeowner control as a starting point. We're sharing that with you on Zoom and also on Facebook Live right now. You can also find it on our website at mulcahylawfirm.com. You may want to reach out to our firm, and maybe I can give you, like a free 5-minute call just to kind of go over what's going on and point you in the right direction. Honestly, while you're in the transition committee, you really don't have a lot of rights other than your rights as a homeowner. But there are some things that you should be aware of that are problems that typically come up during a transition time, and want to make sure that you have those on your radar and that you do not sign any sort of a acceptance or a release of the developer. That's the most important thing for the transition team. You should have separate legal counsel, not the same legal counsel that the builder uses for the association. So whoever's the attorney for the association right now, I mean, I'm sorry to say this, but the developer is controlling the board. So you got to be really careful. That's not your attorney as the transition team. You need to get a separate attorney to help advise you through this process. Okay, question 33, last 2 questions. We have a homeowner who gave the board a bill for electricity that they are claiming their mother let the board use for a sprinkler timer. Is there a statute of limitations on how long the estate has to make this claim? Okay, I think this is a clarification from the earlier question that I didn't understand. There's a 6-year statute of limitations on breach of contract. I guess what I would say is, number 1, was there anything in writing on this? Number 2, the mother's deceased. So it's kind of questionable as to, this claim is being made after the mother passed away. Is the sprinkler timer really on, that lot's electric bill? If it is, you really should be switching that, because it's not really appropriate to have doing this reimbursement. You should just have everything be nice and clean. Everything should be in the association's name. So I'd say reach out to your association attorney, my law firm, to talk about this. I mean, I'm kind of leaning towards, I don't think that this is something that I would pay as the board, but I'd have to hear more. Like if there was something in writing, to go 6 years back based on breach of contract. But I'm leaning towards thinking this is not something that I would advise the board to pay, but I have to hear more. Okay, question 34. This is going back to the new legislation bill. Let's see if this is actually the last question. Oh boy, this bill is a long one. I'm not sure I'm going to be able to answer this quickly. So let's see. You're asking me, get this House Bill 2084. You're talking about proposes to strike the ability to give notice of meetings via pamphleting, via delivery to each unit, and requires in-person notice or delivery to registered email address. Okay, so it sounds like they're changing the method, or this proposal is potentially changing the method to deliver information regarding the association to registered email or address. I guess your question is, wouldn't this change or inhibit the members' right to call a meeting to conduct business, including recalling a board, as members do not have access to registered contact information, and rental units do not allow for ease of in-person contact to assure notice of 100% members? Okay, so it looks like this particular section talks about written notice. So this is a type of notice that would be this new law. It's proposed. This is not the actual law in Arizona. This is proposed law that says that, meetings of the membership can be called, a certain way. And then the notice of the meetings of the membership can be done by the following means. You can give it in person. That's been what the law has always been. It's one way. By mail to the physical address of the member's lot, which is the way it is right now, or the alternate mailing address designated in writing by the member, or by email. This is the addition to the email address designated in writing by the member. I guess from my perspective, I'm okay with this bill. I really am. It gives us another method to notify the member. The member can pick which way they want to be notified. I mean, it's very rare that people are getting notice of meetings in person unless your association is really small, like 10 or less homes. I'm okay with it. And I don't think it does impede, because I think if there's an email address that's designated in writing by the member, I think that's now a book and record of the association, and it can't be considered a personal record. And we'll have to give you that if you want to notify the membership of something yourself, if you want to call a special meeting. Also, remember that if you says you're calling a board, really the board sends out the notice anyways. So you're not going to have it's not, the issue that you're raising is really not going to matter because the board is going to be the one that provides notice. And if they'll provide notice the way that the owners request under this new law, this goes into effect. So good question. I like that you're thinking. I'm okay with that if it does pass, which it would make everybody's life a lot easier because sometimes we have difficulty finding people. And email, let's face it, it wouldn't be the only way to communicate with them, but it would be another way to get a hold of them and notify of things going on in the association, including special meetings of the membership. Okay, so we had a great class today. We are right at the almost 2-hour mark. We've got about 3 or 4 minutes left. I want to remind you of a few things before we finish up today. First and foremost, thank you for joining us for class number 1 of our 2024 Virtual HOA Academy, our January class, and also for our first Friday that we had earlier this month. I am looking forward to being in Chandler for the Mayor's HOA Roundtable. I also have a couple events that are coming up here in the very near future. And that is teaching a class with City of Scottsdale on Saturday, January 27th. It's their HOA and condo symposium. And I'm going to be talking about a number of different topics there. And also I'm going to be teaching a class in City of Scottsdale on February 6th. So we have a couple in-person things coming up, which is mostly over the past 3 or 4 years we've been doing Zoom. So couple of opportunities, 2 in January, Chandler. Tomorrow night, I'm going to be at the City of Chandler for the HOA roundtable with the mayor, and that's, I think, going to be limited to Chandler residents. You can find information on that by going to our website or looking at the City of Chandler's website on the mayor's HOA roundtable. Also, upcoming Saturday, I'm going to be teaching a class in Scottsdale, HOA condominium symposium. You can find information on that on our website. And then also in February, we're going to be teaching a class in Scottsdale on February 6th. And I think that's on our website, but if not, it's going to be up there really soon. I'm really happy to announce today that we had over 155 attendees today on Zoom and many more on Facebook. Like that's got to be a record for this year and last year. So happy that we had such a great turnout today. I think it was a good topic because we covered a lot of different things and we kind of did some planning for 2024. So thank you so much to everybody for being here today. I'd also like to thank the different cities that we partner with to teach these virtual HOA Condominium Academy classes. Again, I'd like to thank Avondale, Chandler, Glendale, Goodyear, Peoria, Mesa, Phoenix, Scottsdale, Surprise, and Tempe for allowing me the ability to partner with your cities and neighborhood services departments in your cities to provide free information to homeowners, board members, and managers so that everybody is aware of what's going on in our industry and has a place that they can go to for free to ask questions and have them answered. Just some closing remarks. Our next First Friday event, don't forget that, is going to also be February 2nd, first Friday of the month, starts at 9 a.m. And lastly, please consider leaving a Google review for these classes or for our law firm if you've worked with us directly before. We are sharing a link in the chat on how to leave a review. We are always happy to get feedback from our valued customers and for those who are attending these classes so that we can continue to improve our service. Also, in order to keep these classes going, it's important that I provide the different cities that we work with evidence that these classes are valuable and that it's a resource that you like because every city evaluates whether or not these classes are something they want to continue over time. And having the direct evidence through a Google review that you like these classes and you would like to continue seeing them in 2024 helps me because I provide that feedback to the cities. So please consider doing that. We would really appreciate it. And again, the Google review link is right there on the information that's on Zoom or on Facebook Live. So thanks again, everybody. I hope you have a great 2024 for your associations. Work on those goals this month for your associations. And I look forward to seeing you at any upcoming classes in person in January or virtually in February. So thanks for being here today and have a great day. Take care.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content in these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.